2.0. Although the Supreme Court ditched half of this case and is almost sure to ditch the other half being the Fourth Circuit, the other half being the Ninth Circuit, they got rid of the first half yesterday. It is coming right back in Greenbelt at the district court level on Monday. So, meaning the 3.0 version is coming back. So it won't be long before we're back in court. Whether we get back to the Supreme Court is an open question. Maybe a little less likely than it was for 1.0 and 2.0, but we're going to hear more about that. I want to briefly introduce everybody. Let me first say that as a Supreme Court reporter, I'm very distressed that we have no travel ban case, but plenty of other cases at the court this term, so you should all come out and see a case or two, which I'm sure you probably will. And I apologize for all the Nats fans that are here who will not see probably 2-3 innings of the game. I'm going to go straight down the line from my far right. Josh Blackman is Associate Professor of Law at South Texas College of Law in Houston, expert on constitutional law and the Supreme Court, which comes in handy for those of us who cover the court. He is the author of Unprecedented, the Constitutional Challenge to Obamacare, and Unraveled, Obamacare, Religious Liberty, and Executive Power. He's an adjunct scholar at the Cato Institute. He is the founder of Fantasy SCOTUS, which he bills as the, quote, Internet's premier Supreme Court fantasy league. We probably have some members of that league here. And he blogs at joshblackman.com. Ilya Soman is professor of law at George Mason University, which is now also named after a certain recently deceased Supreme Court justice. He's an expert on constitutional law, property law, and the study of popular political participation and its implications for constitutional democracy. He's the author of Democracy and Political Ignorance, Why Smaller Government is Smarter, and The Grasping Hand, Kelo versus City of New London, and the Limits of Eminent Domain. I'm being brief here. They may have much longer bios, but I wanted to just give you a taste. Amir Ali, on my immediate right, is the Supreme Court and Appellate Counsel at the MacArthur Justice Center and the founder of its DC office. He will be co-teaching a spring semester here on constitutional litigation under the current administration. I don't know why he's expecting any litigation under this administration. He will also be lecturing and be the director of the Civil Rights Appellate Clinic at Harvard Law, and he's filed briefs for the MacArthur Center challenging the constitutionality of the travel ban executive orders. And he blogs at Take Care blog. Ilya, I neglected to say where you blog. Where do you?
I blog at the VOA Conspiracy blog at the Washington Post website.
So with that, I'm going to ask Josh to take us back to travel ban 1.0 January, 2.0 March, 3.0 September.
Thank you. It's a pleasure to be back at Georgetown. We have a distinguished company, Randy Barnett, and others are in the attendance with us. Also, Ilya was my property professor at Mason, so I'm always happy to be on the stage with him. And Amir, we've corresponded before, but this is the first time we've had a chance to interact on a panel. So I'm grateful to talk about the travel ban. This is a topic that keeps evolving every time I give a lecture. Before I begin, I'd like to make a note. I feel much about the travel ban as Justice Scalia felt about flag burning, or perhaps taking a knee. In the sense that Justice Scalia didn't like flag burning, but he felt that the Constitution protected it, and he voted in the case of Texas versus Johnson in a way that conflicts with his personal beliefs. As a matter of policy, I think Ilya and I are quite close. I disfavor this policy. I think it's quite awful. Will do very little to keep us safe. In fact, I would have a much more liberal immigration policy than what we have now. But that doesn't inform my views of the constitutionality of these policies. So with my cards on the table, let's go back to January 27th. Less than a week after the inauguration, President Trump issued the first policy, which we'll simply call 1.0 to keep it easy. Under the terms of the executive order, for 90 days, certain aliens from Iraq, Iran, Libya, Somalia, Sudan, Syria, and Yemen, 7 countries that were deemed detrimental to American interests, we denied entry. As well, for 120 days, the refugee admission program would be suspended. Syrian refugees, in particular, would be denied entry indefinitely. Almost immediately after this order was signed, chaos was unleashed as people started landing at airports and they were being detained by officials. Granted, when they got on the plane, their papers were in order, everything was fine. But by the time they landed, this new policy was in effect. Federal judges immediately issued their release under habeas corpus writs, and shortly thereafter, a federal district judge in Washington issued a nationwide injunction barring the enforcement of 1.0. About a week later, the Ninth Circuit Court of Appeals affirmed that order, even though it was styled as a TRO. The court upheld it as a preliminary injunction. There's some procedural mess there, which I don't have time to go into. The government did not appeal that judgment to the U.S. Supreme Court. They said, let's try it again. So on March 6, 2017, President Trump issued a new executive order on immigration that superseded 1.0. So what did 2.0 do? First, it removed Iraq from the list. It also made clear that lawful permanent residents, that is green card holders, were not subject to the ban. Also, it shifted the justification. Instead of querying whether aliens in those countries would engage in terrorist attacks, which I think was always the wrong question, the new order said that we need to determine these countries share adequate information with Americans and have adequate diplomatic relations to screen people. This order, too, was challenged in court, and you had several injunctions. A district court in Maryland issued a nationwide injunction. A district court in Hawaii issued a nationwide injunction. Those decisions were upheld by the 4th and 9th Circuits, respectively. The 4th Circuit held that the order drips with animus, which was a verbatim quote from the en banc decision. The 9th Circuit had a slightly different position. They said that the president violated the statutory framework, which maybe I'll get to later if we have more time. The government then filed an emergency appeal to the Supreme Court. Over the summer of 2017, there were 3 appeals to the Supreme Court. And these were issues about who should be let in during the pendency of the appeal, for example. Was grandma and grandpa, is that relation close enough to fit within this bona fide standard that the court announced? In each case, the 9th Circuit basically ruled against the Trump administration almost entirely. And in each case, the Supreme Court reversed, in part. These were not unqualified victories for the Trump administration, but I think they show that the 9th Circuit perhaps went too far. But all this song and dance, and this was a lot of briefing, was basically somewhat for naught, because everyone knew that after 90 days, this policy would run its course. And that would happen on September 24th, which was about 2 weeks ago. On September 24th, President Trump issued the third order in the form of a presidential proclamation. DHS created a baseline for each nation to meet and measured whether every country met that baseline. A number of countries were found to be deficient, but after further engagement with the Secretary of State and Homeland Security, these nations came up to snuff. In the end, there were going to be 7 nations on the list of countries that did not comply. So first off, congratulations to Sudan. You are now off the list. But joining the list were 3 nations: Sudan, North Korea, and Libya. Now, I'm sorry.
Chad.
You're right, sorry. Chad, North Korea, and Venezuela. Sorry. So, first off, North Korea, as you might imagine, doesn't have many aliens entering the United States. So that's basically a worthless addition. Venezuela only affects certain diplomatic officials. So it's a fairly narrow application. The only country that has any merit is Chad, which, if you don't know, is a majority Muslim nation in Africa. The president accepted the secretary's submission of all 7. Almost immediately after this third order was signed, the Solicitor General, immediately after this final order was signed, the government asked the Supreme Court to drop the appeal. To basically order more briefing on what to do. And the Supreme Court agreed and they ordered more briefing. Then the Supreme Court issued an order saying, should we dismiss this case as moot? The Solicitor General said, yes, dismiss this case as moot and vacate the decisions of the 4th and the 9th Circuits, get them off the books. The ACLU and Hawaii, represented by your very own Neil Katyal, he's basically the de facto Attorney General at this point for Hawaii. I don't know if he's billing, but if he is, he's got a lot of hours. So they asked the court to, first off, not dismiss it. They said the case is not moot. There's something called the voluntary cessation doctrine, where if the government continues to basically break the law but says, oh, judge, we're reformed, courts maintain jurisdiction. They also said, in the event that you do dismiss it as moot, to keep the lower decisions up, not to vacate the lower court decisions. Last night, after Ilya and I debated this yesterday, the Supreme Court gave us a bit of a surprise, not to me at least, but the court said we will dismiss this in probably about 2 weeks or so. That case involves the refugee ban, which has a slightly longer time period. It was 120 days versus 90 days. So once that period runs its course, I fully expect the court to vacate and remand the Ninth Circuit decision. So after 8 months and thousands of pages of briefing, we're basically at square one, right? We're starting from the district court all over again. And I understand that complaints have been filed in Maryland and in Hawaii and in other courts challenging the most recent iteration of this policy. So we'll probably talk at some length about the actual merits of the Establishment Clause and the free exercise clause. But I want to focus on the court's order last night to give you some new breaking news and stuff that Ilya hasn't heard yet, right? I got to keep it fresh. So there was one sentence in the court's opinion last night. It's only four sentences. There was one sentence I want to read. Following our established practice in such cases, the judgment is therefore vacated and the case is remanded, blah, blah, blah. And in my mind, the most important words in that sentence is following our established practice. One of the points that I've been making about this case since the outset is that the lower courts have not been following established practice. They've been using a set of rules that simply have never been used before. They've extended the Establishment Clause to places it's not gone before. They've looked at president's campaign statements, which is something that's never been done before. They've done a lot of things in issuing these nationwide injunctions that are frankly, Randy, what's the word?
Unprecedented.
Thank you, and I swear that wasn't rehearsed. Unprecedented. Yet, despite thousands of pages of briefing and 80 amicus briefs, the Supreme Court treated Iraq v. Trump according to, quote, established practices. They cited a case called Burke v. Barnes. Has anyone ever heard of Burke v. Barnes? I hadn't. This was a fairly mundane case where a bunch of members of Congress challenged President Reagan's pocket veto. Not exactly earth-shattering kaboom, right? And the court said, well, we're going to use this precedent to dismiss the travel ban case. In the grand scheme of things, Burke v. Barnes was a nothing burger. I'd never heard of it. But the Supreme Court saw Burke v. Barnes as giving the rule of decision for Iraq v. Trump. Now, the exceptions to mootness are flexible in light of the voluntary cessation doctrine. Also, the exceptions to what's called Munsingware, this doctrine where you vacate lower court decisions, is very pliable. Hawaii and the ACLU are very smart lawyers. They gave more than enough reasons for the court to keep the case in the calendar, or in the alternative, leave the precedents in the books. If the justices indeed viewed Iraq v. Trump as the next Korematsu, they could have found exceptions with ease. None were warranted. Not even Justice Sotomayor agreed to keep the case in the court's docket, though she alone would have allowed the Fourth Circuit's decision to stand. Yesterday's unsigned order continues a trend that I've chronicled over some months. At each moment where the Supreme Court had the opportunity to hand the federal government a resounding defeat, the justices have declined. If the Fourth Circuit was correct that the president's order drips with religious intolerance, animus, and discrimination, then they would have found a way to keep jurisdiction. If the Ninth Circuit was correct that the president failed to meet the statutory criteria to exclude anyone, then there was no harm in letting the lower court decision stand. Yet the Fourth Circuit decision is no longer precedential, and the Ninth Circuit decision will soon be wiped from the books. As I wrote on the Lawfare blog a few weeks ago, these decisions must be quarantined as byproducts of a judicial panic that should not be cited going forward. And that's exactly what the Supreme Court has done. Now, it's true the justices maintained that they, quote, express no view on the merits. But at this point, my friends, who are they kidding? If any of the findings of the Fourth and Ninth Circuit had merit, the justices should have kept the case. They should have fallen over themselves to uphold civil liberties and vindicate the separation of powers. That did not happen. Now, eventually this case will come back to the courts on the merits. But this delay was not by chance. Rather, it was part of a deliberate strategy. Despite this never-ending spate of nationwide injunctions, the government has always been in the driver's seat, not Professor Cocktail. Jeffrey Wall, who served as the acting Solicitor General, has situated the government for victory where few predicted it was possible. Basically me. That's not the only one. Critically, rather than considering the first or second iteration of the policy, the justices will now consider the third and final proclamation. Now, one thing for you to note. When Justice Kennedy votes to grant a stay, in almost all cases, he votes to reverse. On 3 occasions, he went along with these stays. Now, we don't know if he actually joined it or not, but Kennedy is a fulcrum of the court. If he didn't dissent, he went along with it. Now, if Justice Kennedy voted to grant a stay on the earlier iterations of the policy, which were much worse, much more poorly drafted, the likelihood of success on the latest proclamation, which is extremely attenuated from the initial claims of animus, is on much firmer grounds. And the decision from last night, I think, bolsters that even more so. So I'll repeat a prediction I made back in January and February. I think the president has the statutory authority to do this. I don't think the Establishment Clause applies to these sorts of foreign policy decisions. If it does, I don't think courts can consider as campaign statements. And even if courts can consider those statements under binding Supreme Court precedent, the court's review is limited to a rational basis test. Is it facially legitimate? Is it facially bona fides? These are standards that are very constrained. And I think that's how you read these precedents. So with that standard, I think this is an awful policy. I think the Trump administration is doing stuff that I don't like. There are a lot of things I don't like. He's yanking NBC's license, whatever the hell that means, right? He says things on a daily basis that make me furious. But I can sit here and say, I don't like the policy, but he has the power to do it. And that's my Scalia flag burning moment. I will yield the balance of my time and welcome Ilya and Amir to explain why I'm awfully wrong. Thank you so much.
Ilya, go ahead.
I'd like to thank Georgetown for organizing this event. And then I guess, are we having microphone problems? Okay, good. Well, bottom line is you can hear me, right? So we're going to press ahead despite these unfortunate technical difficulties. So unfortunately, we are not going to get a travel ban oral argument of yesterday like we were supposed to originally or today, but instead you get this even more exciting event. I'd like to follow Josh in getting into various technical legal details, but at its heart, this case is actually very simple. It comes down to 2 simple propositions. One, this order, 1.0, 2.0, 3.0, and 4.0 if there is one, but it's basically the same as the previous ones, is in fact motivated by an effort to discriminate against Muslims. In fact, there are few, if any, cases where there are more blatant efforts at discrimination that the Supreme Court has considered. Second, there is an important question of whether the Bill of Rights applies to this kind of decision-making with respect to immigration and entry into the United States in the same way that it limits every other federal government power. And in my view, the answer to that question is yes, though I admit there is some dispute over it. So let's take the motivation for the travel ban order. It goes back to Trump's now notorious statement in December 2015 that he wanted to institute a Muslim ban. And he continued to say that he wanted to institute a Muslim ban for many months until the summer of 2016, where he switched to a so-called territorial policy, where he would target particular countries rather than explicitly target Muslims. However, on 12 separate occasions, he reiterated repeatedly that the territorial policy was in fact the same thing as a Muslim ban, was intended to achieve the exact same objective. In one instance, he even said that the territorial policy was just an expansion of the previous policy. The similar statements were made by key advisors involved in the drafting of the various travel ban orders. For example, Rudy Giuliani, in a statement made, by the way, after the election, one of Trump's advisors was involved in drafting the policy. He said that Trump had told him that we have a Muslim ban, now make it legal. This is a blatant and in many ways a classic case of pretextual discrimination. Since the 19th century, the Supreme Court has made clear that in some instances, a policy that's on its face is neutral can be struck down as unconstitutional discrimination if evidence emerges to show that the real purpose of the policy was to engage in discrimination on a prohibited category like race, ethnicity, gender, or in this case, religion. And the Supreme Court has actually set up standards from its usual practice, no less, which show what kind of evidence you're supposed to consider when you address pretextual discrimination claims. In the leading precedent on this issue, the Arlington Heights case from 1977, the Supreme Court says the court should look at, quote, the historical background of the decision in question and the specific sequence of events leading up to the challenge decision. I think it's blatantly obvious that Trump's campaign statements and statements afterward a campaign are indeed part of the specific sequence of events leading up to the challenge decision. If there's anything unusual about this, it's the large number of such statements and how blatant they are, and also the fact that this is a relatively simple case due to the reality we have only one decision maker whose motives are important here. Many cases involving pretextual discrimination deal with the motives of multi-member legislatures or committees or the like, where it may be difficult to figure out who did what for what reasons. Here, we're looking at the motives of one person, the president, and his motives are not actually that difficult to discern because he has repeatedly talked about them many times. Now, some people, including Josh, say, well, there's a difference between campaign statements and statements made after the person has taken office. In our previous debate, Josh analogized taking office to a kind of baptism where you become a new man. Maybe as a secular person, I lack the religious faith that's necessary to fully fathom the nature of baptism, but it sounds like a load of hooey to me. He's the same man now that he was during the campaign. He's trying to carry out the same promises. I think that's very blatantly obvious. This is true on the basis of common sense. It's also true on the basis of social science research, which shows the presidents, for the most part, make strong efforts to carry out their major campaign promises, especially those which, like this one, were made repeatedly and are very important to their political base. So I think it's pretty obvious, applying perfectly normal standards, what the motive is. And it's also obvious that we should take account of campaign statements. There's nothing in the doctrine or in the relevant precedents or in logical reasoning or in common sense which says that we should just close our eyes to this very obvious source of evidence. To do so would be to close judicial eyes to blatantly obvious realities. It would also create a roadmap for discriminatory policies going forward. Candidates who wanted to put them through could simply talk explicitly about what they're doing during the campaign. Then they can modulate their rhetoric down afterwards when they get elected, and they could get off scot-free. Trump may not be capable of the necessary self-discipline to do this, but most politicians are, and so we don't want to create this kind of obvious roadmap for discrimination by setting a new precedent never before seen in the Supreme Court. It would be unprecedented, in fact, of distinguishing between campaign statements and other sources of evidence of discriminatory intent. And here, I think discrimination on the basis of religion is something that is unconstitutional, in my view, most clearly under the Free Exercise Clause of the First Amendment, but Establishment Clause jurisprudence has said that the Establishment Clause precludes discrimination on the basis of religion, as well as direct establishment of official faith. To my mind, it would be better to deal with this under the Free Exercise Clause, but it's much better to strike it down under the Establishment Clause than to simply leave it alone. So the remaining and more difficult question here perhaps is, well, maybe there's some kind of special exception for immigration policy. The usual standards don't apply. If you look at the text of the Constitution, this simply isn't the case. The First Amendment says Congress shall make no law respecting an establishment of religion or the free exercise thereof and the like. It doesn't say except for immigration law or except for aliens or except for people located outside the United States. This clear categorical reading of the text is also in conformity to founding era practice. For example, Nathan Chapman, in important recent work, has shown that during the founding era, when we captured pirates on the high seas, suspected pirates, they had to be subject to the same protections of the Bill of Rights under the Due Process Clause, for example, as anybody else, even though they were foreigners and they were outside the U.S. What is true of captured pirates, the most heinous violators of international law, is surely true of people applying for visas, potential immigrants, and the like. It is true that there are cases beginning in the late 19th century outlining the so-called plenary power doctrine, which suggests that maybe there is an exception for immigration policy. I don't have time to go through all the relevant precedents right now, but they're not all, but for the most part, they're not what they're supposed to be. In many cases, all they do is just apply to immigration law the same standards of constitutional law that apply in domestic cases, like in some cases expelling people or deporting them based on their being communists. These cases date to the 50s, at a time when the Supreme Court also said that you could go to prison for being a communist. Even if you're an American citizen, you could. Even in the famous case of Klein-Means versus Mandel, which is much cited in this litigation, that's a case where the plaintiffs did not even challenge the idea that it's constitutional to exclude someone because they're a communist. They just challenged the Attorney General's refusal to grant a waiver for this policy. If the actual issue of whether it's constitutional to exclude somebody for being a communist has been addressed, perhaps you get a different outcome. Even if you take that precedent at face value, it says that a reason for exclusion must be facially valid and also bona fide. Bona fide, I think, means that it has to be in good faith. In this particular case, it pretty obviously is not in good faith. Now, it's also the case that in some instances, even if there is evidence of discriminatory motive, the government can still prevail in the case by showing they would have done the same thing anyway. There's a good reason for the policy. But as Josh suggested, in fact, for this policy, there's no real security rationale for it whatsoever. In fact, the total number of Americans or of people of any kind killed in terrorist acts by migrants or visitors or refugees from any of the countries covered by any of the iteration of travel ban over the last 40 years, that total number is 0. There are a small number of incidences where there were terrorist activities that didn't result in death. Still, it's a much lower incidence of terrorism for these people than for native-born Americans. So there is no real security rationale here. That might not matter in and of itself, but it does matter in a case where you have strong evidence of discriminatory motive, where there are statements targeting Muslims, and nearly all the people covered by the travel ban are in fact Muslims. If the government wants to get around that evidence, they need to show that there's some real security rationale that would have led them to adopt this policy anyway, and they haven't even come close to doing that. I'd like to briefly talk about the 3.0 iteration of this and why, frankly, it doesn't make much difference. 5 of the 6 countries on that list are actually 5 of the 6 countries covered by the second travel ban are also covered by this one. Chad, which has been added, is also a majority Muslim country. For the reasons noted by Josh, the additions of North Korea and Venezuela are almost certainly just a smokescreen because they exclude almost no actual people. There is the so-called information sharing rationale. I would just make 2 points about this. One is that it's not clear why this information is desirable, given that the security risk from people from these countries is already close to 0, even with whatever deficiencies of information there are. Secondly, even if you take this information rationale at face value, it turns out that there's no rhyme or reason to which countries are excluded and which ones are included based on the various information sharing standards. I don't have time to go into the details of this, but if you're interested, David Beer of the Cato Institute has an excellent article on this subject that he posted on the Cato Institute website just a couple days ago. I think it's pretty obvious that the information sharing, like the terrorist argument, is in fact a smokescreen for the real motives, because it just doesn't add up even in a minimal way of being internally consistent, much less in actually promoting security. So Josh talked a lot about regularity and what kind of precedent this might be. If you apply the same standards to this case that we apply to pretextual discrimination cases generally, it should be struck down. It's not a Trump-specific standard, it's a motive-specific standard. Any other president had adopted a similar policy following similar statements of his intent should have been treated the same way. It is true that the Supreme Court has been in some ways reluctant to wade into this and decided to dismiss the case based on mootness and the like. I don't know why they did it. Maybe they actually believed that mootness standards required this, but it may be Josh is right and they actually want to support the government. If so, they could have taken the case and ruled in their favor now. But I think it's also possible that if this could be a major precedent constraining government power in this area, that they want to make sure all the T's are crossed and the I's are dotted, and they want to avoid lingering doubts about some possibility that a decision on travel ban 2.0 might be inappropriate because they really should have waited for 3.0 to come back up to them. Whatever the case may be, this litigation is going to continue, and I think there's a good likelihood that it will return to the court, and hopefully we'll be right back here at Georgetown discussing it when that happens. Thank you very much.
Thank you to the Federalist Society at Georgetown and to ACLU at Georgetown and the Muslim Law Students Association, among the other sponsors of the event, for having us. And I'll just put in a quick plug. For those of you who are interested in constitutional litigation, I will be co-teaching a seminar with Joshua Max in the spring semester. It's not going to focus so much on the merits, although we'll touch on that, but we'll look at the travel ban case, the Emoluments Clause case that's going on, and the Sanctuary Cities case.
You know, with Alexander Hamilton or no?
What's that? I didn't catch that.
Let that one go.
And we'll be focusing more on strategic issues in litigating constitutional cases. The seminar hasn't quite been calendared yet, but it should be next week or the week after if you're interested. So a lot has been said, and I'll try not to repeat since I'm going third. But I'm going to touch on three things, I think. A little bit to do with the historical record and the pretext underlying that still underlies the third order and the animus that underlies the third order. I'll touch a little bit on the idea of campaign statements and explain why I think this whole argument about whether you can or cannot look at campaign statements is just an academic question that really isn't really important in the litigation itself. And then I'll talk a little bit about the Supreme Court's most recent order from last night and some of the observations that Josh and Ilya made just moments ago. So Josh mentioned the case called Korematsu, and in case there are one else in the room or people who aren't familiar with the case, that was a case in which the Supreme Court upheld orders during World War II, upheld orders ordering the internment of Japanese Americans. The decision of Korematsu is now referred to as anti-canon, which is basically a fancy legal way of saying if you're citing Korematsu or somehow your case relies on Korematsu, then you're wrong. And whenever Korematsu is invoked, as it has been many times throughout this litigation, I think it's important to pause and think about whether this is Korematsu, because it really is a shameful part of this country's history. And I think that, and I'll even say, I think that the government's briefs in this case do a lot to sterilize the record in this case in a dangerous way. And so Ilya touched on some of President Trump's comments about Muslims and his religious animus. And I just want to stop and talk a little bit about some of the other things he said, because I think you can't really look at this case without thinking back to those moments. And a lot of people in this room probably weren't watching Donald Trump's rallies at the time. So Donald Trump, for months, traveled around the country and called people who practice the Muslim faith a, quote, problem, over and over again. He advocated that there's no difference between radical Islam and Islam itself, which obviously has a very direct tie to the idea that the travel ban can be based on enemies. He not only did that, but affirmatively disseminated propaganda. There are many examples. I'll share one. He would go around telling a false story about General Pershing. He's referred to the story since being elected president. In fact, he referred to it just a couple of months ago. The story he tells about General Pershing is that he was able to end terrorism for about 30 years. He differs on whether it's 25 or 30 years, just makes it up. And he says that the way he was able to do that was by taking bullets, dripping them in pig's blood, and then executing the people. Of course, the direct implication being that terrorist equals Muslim. Again, relevant maybe to what we're talking about today. He then made promises to shut down mosques, to survey Muslims without suspicion, and to register Muslims in America. And when he was asked, doesn't that sound a lot like what the Nazis did to Jewish people, he said, "You tell me." And they said, "Well, aren't you worried? This is actually something that happened. Doesn't it give you pause to be associated with things that Hitler did?" And he literally responded, "No." And then went on to cite what happened in Korematsu. He went on to talk about the internment of Japanese. So I just raise this record because it's important to pause and think about this, and it's easy to get caught up in the doctrinal issues without really appreciating the gravity of the case and why this actually is a serious case. Then he goes on to discuss what Ilya talked about, which is specific promise to ban Muslim people from America. And not only does he do that, but as Ilya mentioned, he's pretty specific about how he's going to do it when he's asked, isn't that blatantly in violation of the Constitution? And he says, no, well, I'm going to do it by speaking in terms of territories, which is what he later did. All three of the orders talk in terms of territories and single out majority Muslim countries. And he specifically asserted the statute that the government is relying on now. And so this wasn't just, as the government says in its briefs, informal remarks or campaign comments. I mean, this was a plan that he has now executed, and he was told time and time again, how are you going to get away with it? And his response was, just watch me. And I think you can't really understand kind of what's at stake from a Article 3 perspective and the power of the courts until you remember that. I mean, this is a direct challenge to the courts. And I'll talk a little bit about why I think the Supreme Court has dealt with the case as it has so far, and I think it has to do with them kind of fighting to make sure that they're not pulled into the political fray and maintaining the legitimacy of the judiciary. So with that background, let me talk a little bit about how this connects to Trial Ban 3, but I just want to say, as Josh mentioned, in the very first week of office, Donald Trump then goes to issue his first executive order. 7 majority Muslim countries that he's picked out. And now we know from national security experts who worked in the administration for the federal government a week before this happened that there was no national security rationale at the time for singling out those countries. We know that Donald Trump at the time didn't consult national security experts in putting out the first order. And we know that he didn't go through normal processes, okay? So with that in mind, maybe just by show of hands, I can ask, who in this room thinks that Donald Trump had the kind of immense foreign policy expertise at that time, or did his own personal research to come up with the conclusion that these 7 countries do not provide enough information for the United States visa program to work? So nobody. And that was the rationale that was given for the first executive order. Happens to be the rationale that was given in the second one and repeated in the third one. And so we start from the premise that that rationale was bogus. I mean, I think that you really can't come to any other conclusion on this. And so by taking the rationale that's being given to us now, even though the Department of Homeland Security has gone through this review, to take that at face value, I think really shows a lack of appreciation for the whole idea of pretext. I mean, there's nothing else the government would have done but what they've done here, if you accept, the allegation that this was a pretextual reason in the first place. And so that's where I am basically with the third order. And doctrinally, I think it does figure in a lot of the ways that Ilya was talking about it, and I think we can talk about more. To accept, just to restate that, to accept the reason articulated in the present order, you basically have to believe that Donald Trump was a prophet of some sort and was able to figure this out on his own, or with Steve Miller or whoever he was consulting who had no experience in these areas. I think Donald Trump thinks he has that innate ability, but I don't think anybody else in the world does. So let me talk a little bit about campaign statements. I'm not going to get into the doctrine, although I'd be happy to if people want to talk about it a little bit more. The reason, and I will say one quick thing about the doctrine, which is that I think at the end of the day, this is more or less the kind of first-year law student confusion between admissibility and weight. The whole idea that relying on campaign statements will chill speech and that they simply cannot be considered, I think is pretty bogus when you look at how specific these statements are. And I think this is what the district judges have all said. They've said this record is unique. That's why we think these campaign statements were enough. In the ordinary case, we'd look at campaign statements, we'd say, okay, well, they said propose some policy things in debates, but we're not going to assume that it directly translated to Enemas. But as I just told you, the statements in this case were incredibly specific. They were a direct challenge to do something unconstitutional. And when you have that in a case alleging discrimination, and these sorts of statements are relied upon in virtually any discrimination case, I think it's really unremarkable to look at them. But again, I said I wouldn't talk about doctrine. So the reason I think that it's more or less an academic question in this case is that we don't just have campaign statements. Josh and others like to raise, for instance, the hypothetical of, well, is Donald Trump forever tainted? What is he supposed to do? That is not the question on this record because he has done nothing. He's never recanted these statements with the camera after having went on the campaign trail for months toting his Muslim ban and said, we all know what that means upon reading the title.
Have you watched a video of that clip? The full video?
Yes.
What was he talking about beforehand?
He read the title and said, we all know.
For 5 minutes beforehand, what was he talking about?
I'm not sure what you're referring to.
He was speaking for 5 minutes protecting national security. That's what that referred to. I apologize. You keep bringing this up. If you watch the video, it's very obvious what he meant.
Well, I mean, at the end of the day, that's one statement he's made.
Okay.
Which is we all know what that means, talking to the people of the American, that he had just went campaigning 4 months.
Who was he speaking in front of in that event? Do you remember? Service members. So Secretary Mattis had just been sworn in. Vice Pence gave the oath. He was speaking in front of service members about protecting Homeland Security.
Well, let's go to other things that he said.
Okay.
So later that night, he went on television on a Christian network and he said, we're doing this to, quote, because we're, quote, going to help Christians.
And what did the first order say? Protect religious minorities who are Christians in those countries.
Exactly. I mean, and we're talking about whether you're violating the Establishment Clause. So that is facial.
But we have laws that protect religious minorities.
Maybe we can get back to regular order here. So
Okay.
one person will finish their talk and then others can respond later.
So since then, he's also repeatedly referred to it as the ban, bringing the continuity to when he was campaigning. And beyond that, he said, prior to the third proclamation, as president, that he would have preferred to go all the way and to do what he wanted to do in the first place. And what he wanted to do in the first place was what he was talking about in the campaign. So there's no way to look at these statements, and I realize you could come up with ways to post hoc rationalize these in your head if what you're trying to do is defend the constitutionality of the ban. But I think that when you look at these in context, and you actually, with a kind of objective view, look at it, I'll mention another comment. He said he derided his own Department of Justice because he said that they went to a, quote, politically correct ban. And I ask you, what could that possibly mean other than he really wanted to discriminate against religions? So let me talk a little bit then about the Supreme Court order from last night. And I think I tend to agree with Ilya that I think Josh overstates the degree to which the Supreme Court is in some way saying things about the merits. I mean, and Josh focused on the sentence about following established practice, which was made specific to Munsing, where if you go to, it was either the sentence after or the one after that, the Supreme Court also said, we express no view on the merits, which you could also look at as a pretty clear statement to the court that they're not trying to lead them in one direction or the other. And just really quickly on the comment of Justice Kennedy and his practice of voting one way or the other on stays, remember, Justice Kennedy did not go along with the 3 dissenting justices on the first day of the second executive order here. Justice Kennedy went along with the per curiam, which was 6 judges, which upheld or denied the stay in large part and created the whole grandma ban issue. And so I think you could look at that and just as easily say that Justice Kennedy and Justice Roberts were prepared to, at least at that time, rule that the executive order was unconstitutional, at least insofar as it was concerning people who have strong connections to the United States. And I'm not trying to suggest one way or the other, but I think it's both kind of premature to suggest that the Supreme Court has sent a strong signal one way or the other. And in fact, this really seems like the prudent thing to do, which is, a new order has come out, the old one is no longer operative. This is what the court would do in virtually any case. In fact, in most cases, they wouldn't have granted certiorari with this weighing in the background in the first place. This is a unique case, so they took it, and realizing, I think, that the prudent thing to do in all cases would be to send this back. And so, I can't say for sure that Josh is wrong on that, but I just think it's premature and an overstatement of what the court is saying there. And I can talk a little bit about why I think the order wasn't surprising. and also that I think it comes at a doctrinal cost, but maybe I'll end it there.
Well, I was going to ask about that order, so maybe we'll, and let me mention now, it's 20 after, we're going to take questions from the audience. There are microphones at the bottom of each aisle here. I'm going to ask a couple of questions, but start to think of your own, and I'll try to get to them within the next 10 minutes or so. I wanted to ask a question. This can go to anyone. Maybe I'll start with Josh on what happened yesterday. The court vacated the Fourth Circuit. Likely they're going to vacate the Ninth Circuit. I think Marty Lederman here has said that's not really important, the vacate or either way. Do you guys agree, or do you think that, you know, this, I think it was the Fourth Circuit that had that language about animus, dripping with animus.
It won't matter.
In a sense, that's erased, but you can't
It doesn't,
really
right.
erase.
So it's erased from Westlaw. So in other words, you go to Westlaw, there's going to be a red flag next to it. So I think for a minute that if this comes back to Chief Judge Gregory, who read a different opinion, no. So from a precedential perspective, it makes no difference. But only Justice Sotomayor, in dissent last night, was willing to let those precedents stay in the book. So in the grand scheme of things, I understand the
Can I
judge...
just jump in? I actually don't think that's correct.
Okay.
It's up to the justices whether they want to note a dissent. And so
That's
the
right.
fact that the rest of them signed on to the order, which doesn't note any justice, does not indicate
That's correct.
in any position whether they disagree.
No,
with
he's right.
Sotomayor.
He's right about that. But only Sotomayor joined in public to dissent on that. But I understand the judge in, was it Hawaii or Maryland, has already asked for a copy of a classified report that the government relied upon. So this is, you know where this is going. This has come back to the court, maybe even this term. I suspect it will. Oh yeah, ruin Rich's summer, but I think it's coming back to the court this
No,
term.
that would be good. That would be, I'd be happy with that. Go ahead.
So I think it matters, but only modestly. It matters that this precedent, for a moment at least, or these precedents will not be on the books, and those precedents could affect other cases that could come up in those circuits during that time. It probably won't matter very much for the disposition of Travel Ban 3.0. It could be that I'm missing something, but I have yet to see any academic or other commentator who thought that the initial Travel Ban 1.0 or 2.0 were illegal, who believes, well, 3.0 is okay. Maybe there is some person I'm missing. If you discover such a person, it will be a scoop for USA Today, but I haven't seen such a person. I have seen a few people who have said that they thought 2.0 was legal, but 3.0 might not be because it goes further, and therefore is further beyond the president's authority on statutory grounds, something we haven't really talked about yet, but I haven't seen anybody go the other way. So I think people's views, including within the judiciary on 3.0, there's a good likelihood they're going to line up the same way as they did on 2.0. As to what this means for what the Supreme Court is thinking about this, you know, I don't know. It could be that Josh is right, but it could be that it's not the case that they're dismissing this because they don't like the plaintiff's case. It could be the case that if they're preparing for a major ruling on this where they would strike down this policy, that they would want to make sure that all of the procedural questions are properly set up so that nobody could attack the ruling based on claims that it's, you know, procedurally improper and it's ruling on an executive order which has already expired or the like.
Just one more. Go ahead.
Well, I would just add, you know, think about what the case would have looked like before the Supreme Court if they hadn't sent it back down. There would have been litigation pending before the court on the second executive order without any record as to how this third proclamation came about. And so the justices would be asking questions at argument that haven't been developed yet on the record about the third proclamation. And just on the actual vacation of the order, I think the biggest cost is in doctrinally just with respect to the mootness doctrine and voluntary cessation, because you basically have a situation here where the government on its own accord unilaterally both constitutionally mooted out a case in which courts below found invidious discrimination and then also got the decision vacated unilaterally. And I think that right now that seems like a way to maintain the legitimacy of the judiciary, but the government will be citing these involuntary cessation cases for years to come.
One of you talked about how the government, I think maybe it was you, Josh, has been in the driver's seat on this all along. Doesn't it look like, you know, they knew at the time in June that 90 days was going to run out in September? Doesn't that give Sotomayor a good argument that this should have been digged, that it should have been improvidently granted, because they always knew there was going to be something else by the time the first week came along, and the SG's office didn't ask
It
for
denied, yeah.
expedited treatment.
Yeah, I mean, this fool over here actually wrote an op-ed in the New York Times back in June saying the court should hear it over the summer. I said, take Salzburg away and hear it over the summer. So what do I know about that? But this was always meant to be a temporary policy, and I don't want to get into the specifics of Munsingware, except to say the government argued all along that this was a temporary policy, so they knew this was coming up. That's why the way that the courts issued the injunctions in the manner they did was never meant to be permanent. But what I mean by saying the government was in the driver's seat is that they knew all along this would happen. They knew all along these opinions would come out, it would look bad temporarily, but it would last a few months, and then eventually they will be able to institute their policy in its permanence. Now, I think Amir raised a fair point. The January order was very poorly drafted. If you actually look at it, there were typos in it, right? There were mistakes. They put wrong section numbers in statutes. Eventually that got cleaned up, but there were lots of errors. Once Sally Yates was fired and you had a new AG and you had Jeff Wall in the SG's office, by that point, I think they got their act together and figured out what was going to happen. The second order was merely an interim stopgap, and the purpose of the second order was to do a review of various countries. Now, I think Billy is right. I think the policy doesn't make much sense, but that's never been the standard for these sorts of things. I think most government policies make very little sense. It's true. And if we try and apply anything more than rational basis review to most government actions, we'll have a lot of nationwide injunctions. So at bottom, it's not that we're trying to hide evidence or trying to make stuff up, although I think a lot of the evidence has been put in an unfortunate and incorrect light, such as the "we know what that means" statement. The reason why I jumped over earlier, Amir, I apologize, but that's often used by people who haven't seen the video. If you actually watch the video, it's pretty obvious what they were talking about. But
I'd encourage you all to see the
Yeah.
video and to also watch the months and months of videos of Donald
Yeah.
Trump saying that
The
this
pre-
is
the
it,
pre-campaign
and then ask
statement,
the question
yeah.
of what he was talking about when he said, "We all
Yeah.
know what that
The,
means."
the pre-campaign stuff, I'm with Amir. That's pretty egregious. For all of his excesses after the inauguration, he did tone down a tad, but unfortunately not enough.
So what was the political correctness while he was president that he objected to?
I have no idea.
Oh, well, it seems relevant because he's president.
I have no. The problem with President Trump, and I mean that sincerely, is I don't know what he's saying half the time. I have an alert whenever he tweets, it alerts me, and I wake up in the morning and think, what the hell did he say? What license does NBC actually have? There is no license. I don't know I don't know what he's talking about. I think most of the things he's saying are pandering to someone who knows what. I don't know what he's saying. It makes no sense. PolitiFact, fact checker, they just tear their hair out. They probably aged the District of Columbia 5 extra years in 9 months trying to keep up with this guy. I don't know. I don't know.
We defend Trump, but in this case, I have to. What he says makes perfect sense to me. He's repeatedly said what his motives are. On a dozen occasions, he said that the territorial policy is equal to a Muslim ban, is intended to achieve the same thing. To quote the saying, we should take what he says both seriously and literally. What he says is not well supported and not well thought out necessarily, but that reflects his true motives all the more so for that very reason. If you imagine a similar record in virtually any other discrimination case, it would be incontrovertible that it shows pretextual discrimination. Imagine an employer who, before he becomes a CEO, when he's trying to get himself appointed CEO, repeatedly says, "I'm going to try to get rid of black employees and not hire them." Then, when he gets appointed, he adopts a hiring policy which on its face is neutral, but 90% of the people fired or excluded based on it are black. It would be very obvious you can make out a discrimination case on that basis, and nobody would say, oh, but when he became the CEO, he became a different person, and you have to ignore his statements that he made before then. So similarly here, the fact that the kinds of things that Trump says make this an easy case. If you had somebody who was clever and more sophisticated in his statements.
What are you saying, Ilya?
Sorry?
What are you saying, if he was clever?
Yeah, if he was clever about the way that he says things, yes. It may be that he has a high IQ. I don't want to get into that particular controversy. But if so, that IQ may not be in evidence in the particular way that he has talked about this particular issue.
So this case, and remember, guys, if you have questions, just come down the aisle and I'll get to them. The professor is going to have one. He'll start us off. But does the delay, and Josh, you said maybe it'll come back to the Supreme Court this term. I don't know whether that will be too soon or not. But we're still dealing with the Fourth and Ninth Circuits.
Yeah.
We know that those are Ninth forever, Fourth more recently liberal circuits. We don't really expect, as Ilya said, 3.0 to make some of these judges change their minds. I suppose you could get different panels, but the Fourth Circuit was en banc.
Yeah, it won't matter.
So we're going to come back with the same rulings, at least back to the Supreme Court with the same rulings. And the Supreme Court might have been split or leaning Trump's way. Does the 6 or 8 or however many months delay affect anything?
So you may be familiar in the Fourth Amendment context with attenuation. We're listening to Crim Pro. And generally when there's some sort of a taint with an original search and seizure, as time elapses from that initial taint, the bad stuff becomes attenuated. I do think that matters. The order went out of its way to explain, look, this is not just Donald Trump being a bigot. This is the entire federal government working in tandem. You had Homeland Security, you had state, you had these various agencies coordinating with nations around the world. That is supposed to suggest that this is not just one person on a mission to exclude all Muslims from the country, that they're actually achieving some sort of policy objective. Now, the courts can say this is all just pretext. I think the phrase today is original sin. You know, we've gone from the apple to the Trump, right? And the original sin from the campaign trail in 2015 will never go away. And then this taint is always there, and Ilya's right, and Trump is the same person, right? If that's the case, that we can simply say that about the president, the presidency of Donald Trump will not go very far. In the DACA litigation, which is in New York right now, the New York Attorney General has argued that Trump's statements to Jorge Ramos show he's an animus towards Mexicans and Latinos, which makes him unable to rescind DACA. It's the exact same species of argument, distinguish it if you will. But if we take this seriously, Trump can't be president. He can't do anything. And maybe people would love that. Maybe that's the judicial resistance wins and we just stop Trump. I don't see that happening.
I'll say, I think that the time matters. I don't think it should matter as a matter of doctrine and the law. I think, you know, like I said, Donald Trump has never recanted these statements. He's in fact supported them. I think it may matter, you know, the further we get away from the campaign and the kind of sentiments I was describing before, I think the danger is that people will forget that this was driven by Enemas. And the pretextual reason in the third order, as I mentioned, is the same as the one he made up in his first order. And so I think there is a danger we get further away. There's also a danger that Donald Trump says more stupid things. And just one other point for people to think about. If this goes to the Supreme Court, and the Supreme Court does kind of in some way uphold the travel ban itself, I think what it would do to Article 3 when Donald Trump is debating next round of presidential elections and says, I delivered the Muslim ban.
So,
does anyone doubt he would say that? Hey, did you think you delivered that campaign promise? Of course he's going to say yes.
I don't know if the time will matter or not matter, but I think what should matter is how closely connected this policy is to the original one. And that's not so much a matter of time, that's a matter of what the policy is and what is the purpose behind it. And when you look at the list of countries and the way people are banned, it's mostly the same countries with the same kind of ban, with the same kind of rationalization, with North Korea and Venezuela added in ways that even Josh admits don't really matter because hardly anybody is actually excluded. So what matters is whether it's still the same motivation, and here the overwhelming evidence suggests that it is. And it's false to say, well, that means Trump can't be president. He can do lots of other policies that can't be traced back to his motivation. He has already adopted lots of other anti-terrorist policies of many different kinds that have not been in any serious way challenged on this. So what's true is that Trump, and frankly future presidents also, should not be allowed to enact policies which can be traced back to discriminatory motivations and which have no defensible alternative justification. That's a feature of this litigation if it comes out the right way, not a but.
Professor Barnett.
Thanks. This has been a, I don't know if this is on. Testing.
Is there a button?
I think there's
a button. Now it's on. Good. Anyway, it's been a great discussion. Thank you all. I have a question for Ilya and Amir, and this is a genuine question. It's not a challenge, and it would help me because I'm in the middle of a big project called Good Faith Constitutionalism, in which I'm using a good faith framework to analyze both judicial, legislative, and executive discretion. And I'm wrestling myself with the idea of subjective intentions and versus objective manifestations or objective policies and the rationality of objective policies in order to ferret out pretext. I agree with Ilya and Amir that this seems like a pretty easy to prove pretextual exercise of power, based both on pre-election and post-election statements. So I'm with you on that. So I guess to help me out here, I am interested in the taint question as an abstract matter, not necessarily in the context of this case, but as an abstract matter. If it is assumed to be true that a constitutional officer, in this case the President of the United States, has a improper discriminatory intent towards a particular group, a constitutionally improper intent, then a policy is executed which is facially neutral. It's not actually a facially discriminatory policy. I think Ilya is right. The standard doctrine when you deal with that is to look at the disparate impact, and the disparate impact only counts if you can prove intent, and you ought to be able to prove intent. But does that mean, and this is I think the argument that's going to have to be faced in court as well, does that mean that this president or this administration, let's put it that way, can never implement a facially neutral policy that has a disparate impact on the group that there's evidence of this intent ever in the course of a 4-year administration? So both of you have stressed, Ilya in particular, Donald Trump has done nothing to purge the taint. I agree. What could he do? What could anybody do? Under your theories of how the law is supposed to work, is this the original sin that cannot be purged? Or is there something that a different president who, and I guess one last thing is, supposing you did have a different president that did have more control, would that mean it was any less tainted actually because they know enough and have enough self-control to say the right things? That really wouldn't change the reality, right? So I'm just curious to have your feedback on this.
So is it okay if I go first?
No, please go ahead.
So I think there are sort of two interesting questions here. One is sort of at what point does the taint end? The other is, well, what about the point, that defenders of the trial minister, well, a different president could do the same thing and it would be okay, and if a different president can do it, why can't Trump do it? I'm going to take the second and easier question first, and that is that it's inevitable in the doctrine of pretextual discrimination that the motive matters, and therefore doing the same thing for a different motive might be constitutional. And you might say, well, then this seems like a silly doctrine. It doesn't make any difference because you can still do that thing. But the fact of the matter is, much of the stuff which is struck down historically and possibly in this case as a result of this doctrine is stuff that would be very unlikely to be done with a different motive. So think of various Jim Crow laws that were facially neutral, but in some cases were struck down because of the discriminatory motive, or think of the law with the Chinese laundries in Yickwo versus Hopkins, which on its face was neutral. It dealt with shutting down certain kinds of laundries, in reality which targeted the Chinese. Absent a desire to target the Chinese, very unlikely that law would have been adopted. So I do think it should not bother us that in theory a different president with a different motive would do the same thing, that's an inevitable aspect of the law of pretextual discrimination, and in most cases a president who lacked that discriminatory motive would not in fact do the same thing. That we can't categorically say that in every conceivable state of the world. As to exactly where the taint ends, I think this is one of those areas where it may be difficult to draw an absolute bright line, but I think what's important is not just that the president or other decision maker in question has a particular prejudice against a particular group. It's that you can create a direct causal link between this policy and that motive. So he himself has specifically said many times that the territorial exclusion policy is meant to target Muslims. So here, there's a pretty clear link. Can there be other cases where it's less clear? Well, that's yes, but the same thing arises in any case, in any area of law where motive matters. There's still a question of whether the motive actually was the true cause of the action or not, and sometimes it's difficult to tell. You see this all the time in employment discrimination law, in many other areas of law. I think the Supreme Court has actually created at least a reasonably decent test in this area, the one that I cited earlier from Arlington Heights, where once there's evidence of discriminatory motive, evidence with respect to a specific policy, not just evidence of general distaste for a particular group, then the burden of proof is on the government to show that they had reasons that would have led them to enact the same policy anyway. If it's really the case that in national security, the executive branch has all this vast expertise, then they should be able to come up with the relevant evidence to show that they would have adopted the same policy anyway. If some of that evidence is secret, there are procedures for hearing it in camera, and I think most federal judges are responsible people who can be trusted to keep that secret. If the government thinks that a particular judge can't, you can file a motion to get that judge to recuse or the like. It's significant, by the way, that despite all the claims of national security expertise, the government in this case has never tried to claim, well, we have secret evidence that we can only show in camera. They haven't availed themselves of that procedure. I suspect that's because there's no there there. Jeffrey Wall, as Josh said, is a very good lawyer. If he thought that this sort of procedure would help him, he would have utilized it.
Yeah, I would echo most of that, and I won't repeat it, but I would just say, courts give very broad discretion to the executive, or if we're talking about a contained situation in a legislative context, also to the legislature. And that's especially in the immigration context, but in a lot of contexts, and for the executive, it's not just even the conservative justices. Kagan and Breyer are very, I think, attuned to those sorts of issues. I think the problem here is that it's the perfect storm of issues. I think you kind of acknowledged not only that the animus is so easy to show before and after him being elected, but the same pretext being offered over and over again that he made up at the beginning. And then also that there's just no justification, no national security justification, no believable justification for it. And so when you have those counting against him, it makes it harder, I think, for him to come out from underneath it and showing that the next policy isn't motivated by enemies. I think that's what he would have to show.
So that's my question, a follow-up if you don't mind, because both, I think Ilya just alluded to this, and I think you did, this national security justification. And I agree, there's no bright lines. I'm not asking for a clear answer, but essentially, are you both suggesting that if the Justice Department or whoever is going to be litigating this thing actually came up, produced a credible national security justification for this facially neutral policy, that notwithstanding all of these perfect storm statements, that policy could still be upheld in your opinion, that should be upheld in your opinion? I'm trying to picture what that would look like.
Yeah. So it's a good question.
As a matter of principle, not that it's necessarily going to happen here.
So I'm not making any prediction of what will happen here. I think it's unlikely that it will happen, but who knows? Maybe Trump is playing 8-dimensional chess, as some people say, and he has this waiting in his desk and he's going to pull it out. But yes, I think if a sufficiently strong justification is produced, and there's evidence that it was a real motivating factor in decision, then at the very least the government's case becomes much stronger. Just as in the Chinese laundry case that I had mentioned earlier, the government's case would have been much stronger if they could really show that the types of laundries that were shut down were really more of a public health risk or the like than the ones that were not shut down, and that would have made more plausible their claim it was just a coincidence that virtually all of them were Chinese-owned and virtually no white-owned laundries were shut down. So I would add, here they don't just have to confront the fact that the evidence that there will be any national security benefit is very weak. There's actually evidence, pretty good evidence, that there will be national security harm from this policy, because among the countries or excluded are places like Syria, where we have an ongoing war against terrorism. We need the assistance. Any military commander will tell you this, or counterinsurgency expert. General Petraeus, General Mattis, and others will say this. It's right in the manual that Mattis co-authored with Petraeus. You need the support of the civilian population in dealing with insurgencies and terrorists. Some of these people aid us at the risk of their own life, and it's common practice to try to give those people shelter in the U.S. in those cases. This policy creates a presumption against letting those people in the U.S. Now, it does say lower level officials in some instances can exercise discretion and let them in anyway. If I were a Syrian who was thinking about risking my life to help American forces, I would not put a lot of confidence in the discretion of lower level bureaucrats. I wouldn't bet my life on that, especially an administration as hostile to immigrants from Muslim countries as this one is. So in this way, it's harming national security. Also, Trump is not the only one who has praised this travel ban. The leaders of ISIS have done so as well. They have issued statements saying it's a blessed travel ban. Why do they call it blessed? Because it deters people from leaving ISIS-controlled territory. It damages the image of the United States in a Muslim world and so forth. The government, again, I think this evidence might not be relevant in a case where there is no evidence of illicit unconstitutional motive, but it is relevant in a case where there is, because it makes the government's burden of proof of showing that they would have done it anyway much harder, especially since the people in the government who actually do have knowledge of counterinsurgency and terrorism, like people like James Mattis, they're on record in their past statement that this is the kind of stuff that you don't want to do, stuff that gratuitously alienates the civilian population in the very areas where you're trying to fight against terrorism.
I'll just say, in my opinion, it's kind of, in my view at least, scary how little he would need to do in that respect if he had some credible evidence to make this happen. Or if he recanted it again, makes it at least a little harder of a case, and depends obviously on how sincere the statements he makes are, or the actions are. I think Justice Scalia, before he passed away, I think it was a while before he passed away, but he said that his view was that Korematsu was wrongly decided. But in this case, he said, we're going to be at war again. And that's what Korematsu was. And when we have that actual national security justification, we're probably going to do Korematsu again. The problem is that we're about to do it, or possibly going to do it, when we don't even have that record.
Next question?
Thanks for being here. I just want to ask about what the state of play is with Shaughnessy. It's been narrowed. There's some arguments that I think your amicus actually kind of dismissed it in one line, but it hasn't explicitly been overturned. Is that correct? So anyway, what the state of play with that is, because obviously it seems like a lot of the arguments being made are kind of hinged on the notion that Shaughnessy is simply not good law, and
What is?
Are you talking about Knopf, Extra Shaughnessy?
Yeah.
Okay. Remind me of the holding of that case. I know it. I'm just drawing a blank.
That was the case that they had detained. It was someone who was here legally, non-citizen, went back to Hungary for an extended period of time, showed back up at the port of Ellis Island, was denied entry. There were some allegations that who he was hanging out in Hungary was not good. That case went up, and the Supreme Court ruling was basically that an entrant alien doesn't have constitutional rights.
Oh, okay.
And
So,
just saying that, as the terms of showing up and knocking on the U.S. door, we can tell you.
Your name is Steve. I'll take a stab at that one. So, actually, Rich, if you read Rich's column in the USA Today, he talks about the Korematsu case, and he actually quotes a conservative blogger who disagrees, and he quoted me. So one of the reasons why I think this case is different from Korematsu, and it's really a fundamental divide between Ilya, myself, and probably Amir, is it involved people in the United States who are actually citizens. And this case is the opposite. It involves people outside the United States who seek to enter. And I think the Shaughnessy case is correct. I think it's good law, and that's the precedent. And people entering the United States don't have a constitutional right to enter. And I'll pause for a moment and note, why is this case an Establishment Clause case, right? Why isn't this a free exercise case, saying that this is restricting their rights because they're Muslim? Why isn't this a due process case, saying they're violating their rights? Why isn't this an equal protection case, saying it's a classification on the basis of religion or whatever else, right? The reason why is none of those provisions apply outside the United States. They don't apply. Immigration law does not control itself by those provisions. The Establishment Clause has been used, I think it's been in a very artful way, to say it as a structural matter when the president takes these actions, he is showing disfavor of Islam, and that's unconstitutional. I think it's a poor fit of doctrine. I guess it works, but this is really a free exercise case. It's really a due process case. But the courts haven't jumped on that. There was some initial due process stuff in the 2.0, but they've abandoned that pretty quick.
So, a couple of thoughts on this. One is, yes, it's often said aliens don't have a constitutional right to enter into the United States, but the doctrines banning particular types of discrimination apply even in respect to discrimination with government benefits for policies that aren't themselves constitutional rights. For example, the court has said you have no constitutional right to get Social Security benefits. Even if you feel like you were promised those benefits, wherever Congress could tomorrow pass legislation saying, sorry, no benefits or lower benefits than you were initially promised and so forth, and there would be no constitutional that, still, it would be a violation of the First Amendment if Congress said only Christians can get Social Security benefits, or that Jews cannot get them, or something or other like. And similarly, with respect to discrimination, with respect to other kinds of government policies which are not themselves, constitutional rights don't apply to aliens entering the U.S. at all. But if you look at more recent cases, they do say that there are limitations. Even Klein-Means versus Mandel says that there are some limitations. That's clearly not in accordance with current Supreme Court precedent. What is somewhat less clear from current Supreme Court precedent is exactly how the limitations work. In my view, which is an amicus brief that I co-authored, which if you just Google my name and amicus brief and travel ban, you can find it and read it for free, no charge. I think you could say that the Bill of Rights applies to entry into the United States in the same way it applies to other discriminatory government policies, while doing very little violence to existing precedent. You wouldn't even have to actually overrule a single case, though you might have to modify some more extreme language that is in some of these cases. I'm not going to try to go through case by case right now, but it's in the brief. And obviously I think that it's not just the Establishment Clause, but the Bill of Rights as a whole, with a few exceptions that specifically mention U.S. citizens or the like. The Bill of Rights as a whole is a structural constraint on federal government power. It doesn't say Congress shall make no law restricting the freedom of speech or the establishment of religion or whatnot, or free exercise when it comes to U.S. citizens or people in the United States or some other category of people. It doesn't say that it's limited to a particular territory. It just says make no law, which is a general structural limitation on federal power. It applies to the immigration power just as much as it applies to other federal powers. Indeed, I would say it applies even more, because the immigration power, unlike some of the others, is not even specifically listed in Article 1. It's something that the Supreme Court more or less made up in the late 19th century, when they say it's got to be in there somewhere because it's an inherent power of sovereignty. So if it applies to the Commerce Clause, for example, which the court has said is a plenary power that's unlimited with respect to its subject matter, then it surely should apply to this power as well.
So Ilya made the structural limitation point I was going to make, and I'll just also just kind of respond quickly to the Korematsu point, because it is possible to make distinctions between Korematsu. The order there, for instance, specifically said people of Japanese ancestry. It did apply to people who were here with unlawful status, and also to U.S. citizens as well. And I think the question you have to ask yourself is, are those distinctions the heart of what makes it such an affront to the Constitution and to our ideals?
Can we get one or two more questions from anybody?
I had a question for Amir. So I'm really interested in the intent argument. I'm a bit curious as to why the entire discussion isn't about intent. Because it seems to me when you get into justification, it gets murky on at least two levels. One being, it's just really difficult to kind of ascribe a certain standard of what is a justifiable policy for a specific administration. I mean, to suspect the Trump administration to be incredibly methodological in how they lay out policies seems unrealistic. And I don't mean that to be as, and the second thing being is we just don't know a lot of what goes on behind the scenes. And I imagine that, my follow-up question to that would it be insufficient for President Trump to look on the State Department's website and see, oh, the countries in red, those are critical security threats? And I think that that's how the infographic is laid out. Would it be insufficient to look at that and say, okay, well, the State Department under the Obama administration created this infographic. They've deemed these countries to be critical security threats, and on that basis alone, is that insufficient? Do we need to be looking into the justification? Why doesn't the discussion end at the whole discussion of intent? That seems to be the most compelling argument. Which, by the way, and my third kind of follow-up question is, the post-election comments seem to be powerful only insofar as they refer to pre-election comments. So that whole line of reasoning makes a whole lot of sense to me, but why isn't intent the beginning and end of the debate here?
Hasn't been in the litigation, at least in brief. So the government itself has tried not to focus on the intent issue, as you might imagine. I mean, they're really not pushing back at all. They never contest that during the campaign he promised to do all this, and he had the subjective intent at that time to ban Muslims from entering the country. And they don't want to focus the argument there for a lot of reasons, and their position has been you can't look at that at all. And in more recent briefs, they've kind of tried to suggest that there's selective interpretation, but again, the record is so large that I think that kind of is not credible, and so I think they've purposely steered away from it. The reason justification has come into it, and my colleagues may have some other thoughts on this, is just doctrinally, there is still at least some lack of clarity. The Establishment Clause jurisprudence itself is very unclear, and some of the justices who would be relied upon here have questioned some of the doctrines that are being relied upon by the plaintiffs. But there is a feeling that there's a need to show that there was no compelling justification here. And so justification, even if you show that there was discriminatory intent, there's a feeling that the justices would want to know, and it's part of the doctrine to show that there was no compelling justification. Just one point you made that's worth being clear on. The example you gave, the hypothetical of Donald Trump going to the State Department website, is basically what he and whoever he did consult on this did. There was a list of countries that were labeled as concerned countries by the Obama administration that he claimed he just picked these from, and therefore he wasn't discriminating against them. The concerned countries list wasn't identified for the pretextual reason Donald Trump gave, but I just raised that actually is part of this case.
So a couple thoughts on this. One is, if this case is solely or primarily about intent, then the administration is going to lose, because the evidence of discriminatory intent is far, far stronger than the evidence of any other kind of intent behind disorder, certainly more than enough to fit the usual civil litigation standard of preponderance of evidence. I would even argue, I think you could probably show that discrimination was the intent beyond a reasonable doubt, certainly you can show by preponderance of evidence that that was the intention. But it is true, as Amir said, that the doctrine doesn't end there, that the government can try to rebut and say we had other purposes. One last point on this Obama list. I think there's a big difference between a list that's created for the purpose of sort of bureaucratic attention or whatnot, and one for a categorical travel ban. And the Obama administration never intended a categorical or near categorical travel ban with respect to these countries. And there's lots of evidence that there's plenty of other countries that pose as great or frankly greater security risks than these do, and almost no evidence that keeping out migrants from these particular countries will actually reduce the risk of terrorism. It's very hard to reduce it below near zero, which is the current, which is what the evidence of the last 40 years of entrance from these countries shows. So again, the fact that it's a bad or an unjust policy doesn't in of itself prove it's unconstitutional. When you combine that with the evidence of discriminatory intent, I think that other evidence is relevant, and it's one reason why the government has tried to take the position, the federal government has tried to take the position that intent doesn't matter, because they know that if it does matter, they will likely lose.
Let me raise a question. Do the usual rules apply to the president? Does Arlington Heights, preponderance of the evidence, burden shifting in McDonnell Douglas, do we simply apply these rules to the president as we would to any other person in the country?
Yeah, I would say
not done. You can jump in a minute. Generally, if a government actor commits some sort of offense, a civil offense during his time, he can be sued. But we know that the president can't. Generally, if a person is committing a crime during his time in office, the person can be indicted and held to criminal trial. Maybe the president can, maybe he can't. Generally, if a person's under investigation, the person can't pardon himself. Maybe the president can. I think the Trump administration has taught me something, and it's a bizarre lesson, that all the various hypotheticals which common law professors fantasize about, saying, what could this happen, are happening. And it makes us reassess what our principles are, what our rules are, and do we apply the same set of rules to the president? And if we don't, what effect does it have in the long term? I don't have answers to these questions. My general sense, this was my sense even before the inauguration, is that the usual rules don't apply to the president. He's a unique office. He's created by the Constitution. There are cameras in lots of courts, but not the Supreme Court, for a reason. Judges are subject to the ethics code, but not the Supreme Court justices. There's a reason why the president's exempt from both ethics laws. He's just not subject to them. There are certain rules that just don't apply to the president. And I think the sorts of civil rules that have been applied to figure out intent would fall in that category.
So that seems like a silly question to me, just because I agree that in many instances the usual rules wouldn't apply to the president, but the Constitution says the federal government, quote, shall make no law. And so the current action against the president and some sort of way of enforcing the Constitution, which Article 3 judges are called upon to do, has to exist. And there are interesting questions when you get to civil litigation against the president under statutes and the degree to which the Constitution limits that. But that's not what we're talking about here. We're talking about a constitutional prohibition, and that's the job of the courts to do in this instance.
I think with Spider-Man it's relevant here. With great power comes great responsibility. So it's perverse to suggest that the person with the single greatest power somehow gets a special exemption from all the usual constitutional rules, except granted in certain cases, the Supreme Court, where it's not Supreme Court, the Constitution specifically grants him an exception, like he has the power to pardon and the like. In this case, he's not being subjected to personal, civil, or criminal liability or the like. He's merely being subjected to the rules which constrain the power of the federal government more generally. And no exception should be granted to him from those rules unless the Constitution specifically creates one. And I think it's perverse to suggest otherwise, and dangerous as well.
So we're going to end with Spider-Man.
So I am both silly, perverse, and dangerous.
Not you,
I
the
come
rule
to,
that you suggested.
I come to Georgetown with good friends, but I appreciate it. No, thank you so much. I
have
ponder
many,
these questions.
many
I'm like,
friends who say things that are perverse.
oh, there are perverse incentives. Rich, any other questions?
We're going to end our
Yeah.
panel here with Spider-Man, and I'd like everybody to give a round of
Thank
applause.
you.
for that.
Adjourned.
Hi, thank you all so much for coming. We have food and drinks outside, so please partake. Special thanks to our panelists and our moderator. We really appreciate you coming out.
Thank you. So what do you think this semester?